So we strongly urge the Court, in considering this, to consider this basic question. May the state proscribe a marriage between such individuals because of their race and their race alone?
On June 2nd, 1958, Richard Loving and Mildred Jeter committed a crime that would put them in the national spotlight and would, eventually, level the scale of equality in America. Their crime? Marriage. Richard Loving, a Caucasian male construction worker, and most importantly, the close friend of Mildred Jeter. Mildred Jeter was a woman of little African American and mostly Native American descent. However, she was classified as colored in accordance with Section 114 of the Virginia State Code, which defines a colored person as any individual who has the slightest bit of African American lineage. Defying common segregation practices at the time, Richard and Mildred fell in love, and soon, due to Mildred being pregnant at age 18, the couple decided to get married. They tried to get married in their home state of Virginia, but were denied because of the Racial Integrity Act of 1924. This act prevented the mixing of white and colored individuals, and it also made a law which required all people to fill out a form identifying their race. This form would have to be reviewed by the Bureau of Vital Statistics in order to be married, and soon, this act would prove to be instrumental in the segregation of marriage in Virginia in the future. The pair flew to Washington, D.C., where interracial marriage was legal, and on June 2nd, 1958, they got married. The newlyweds then proceeded to move back to their home in Central Point, Virginia, hoping to live a full and happy life together. They lived this dream for ultimately 5 weeks before the police broke into the Lovings' house on July 11th, 1958 at 2 a.m. and found them sleeping in their bedroom. Almost immediately, the local sheriff began to handcuff the Lovings, despite their feeble attempt to show their marriage certificate, which was then said by an officer not to be valid in Virginia. This officer was referring to Section 2058 of the Virginia State Code, which states that all interracial marriages that happen outside the state with the intention of returning shall be punished, as outlined in Section 2059.
The night we were arrested, I guess it was about 2 a.m. And I saw this light, and I woke up and it was the policeman standing beside the bed, and he told us to get up, that we was under arrest. They carried us to Bowling Green and locked us up. And in January, they had the trial.
After being arrested, the couple was taken to the Virginia Caroline County Circuit Court. There, Judge Leon M. Basil found the couple guilty of breaking Section 257 and 2058, and then decided to imprison the couple for 1 year, abiding by Section 2059, which states that the punishment for breaking Section 2058 is imprisonment of 1 to 5 years. However, the Lovings agreed to a plea deal which stated that the Lovings would leave Virginia immediately and would not return for 25 years. After the court case, the couple moved to Washington, D.C., where they remained married. 5 years later, after much struggle, tired, the Lovings returned to Virginia in order to meet Mildred's relatives. However, instead of a peaceful visit, they were arrested once again for stepping into Virginia before their sentence was complete. After much discomfort, Mildred became tired and was determined to fight back and to make their marriage legal. She then later contacted the former Assistant General, Robert F. Kennedy, seeking help and guidance. Seeing the unfairness in the Lovings' ruling, Kennedy referred them to the American Civil Liberties Union, or the ACLU.
The ACLU is a non-profit organization whose mission is to defend and preserve the individual rights and liberties guaranteed to every person in this country by the Constitution and laws of the United States. The ACLU took the Lovings case and appointed 2 young attorneys named Bernard Cohen and Philip Hirschkopf to the case. 2 months after Hirschkopf graduated, he met Cohen. He had a Loving case, but he had no background either in constitutional law, civil rights law, criminal law, or appellate law, so he asked the professor if he could advise him. The professor introduced him to Hirschkopf. When we interviewed Mr. Hirschkopf, he said, quote, "At that point, he told me what he had done. I realized he made a big mistake," end quote. The mistake he was referring to was the fact that the case was a criminal case. They said that the banishment sentence of 25 years is illegal, and it was. But when Hirschkopf saw it, he understood that they would also have to go after the constitutional basis, which is, does the Constitution give the right to marry anyone you please? Hirschkopf would take on the equal protection while Cohen took on the due process. In November of 1963, the Lovings' final legal battle started with the aid of Cohen and Hirschkopf. Returning to the Virginia Circuit Court, the quartet went to Judge Bazile saying that Section 2058 and 2059 were unconstitutional under the 14th Amendment, which states, quote, "Nor shall any state deprive any person of life, liberty, or property without due process of the law, nor deny to any person within its jurisdiction the equal protection of the laws." End quote. Despite their best efforts, Judge Bazile refused to overturn his ruling, as he wrote, quote, "Almighty God created the races white, black, yellow, Malay, and red, and he placed them on separate continents. And but for the interference with his arrangement, there would be no cases for such marriages." End quote. Sad but not giving up, the Lovings decided to take this case to the Virginia Supreme Court of Appeals. Later on, the Virginia Supreme Court accepted their case. However, after debating this case, they ruled that these sections were constitutional because the same punishment was being given to both individuals. In their explanation, they referred to the case of name versus name, which was also brought on the legalness of the Anti-Miscegenation laws in the Virginia Code. However, the marriage of the pair was annulled because of the Racial Integrity Act of 1924, and the Virginia Court of Appeals argued that there was a similarity between the cases, so the Lovings' marriage remained illegal. Finally, the Lovings decided to take this case all the way to the Supreme Court in DC by sending a permissive appeal to the Supreme Court, and the Supreme Court only grants about less than 5% of cases. Shortly, their appeal was accepted by the Supreme Court and oral arguments took place on April 10, 1967.
When we interviewed Philip Hirschkopf about when the appeal was accepted, he stated, "That was a very exhilarating moment because I felt then the odds were over. Well, we could win the case." During the trial, Hirschkopf pushed the argument of racism as he said that the sections were racist and rooted with white supremacy. He famously stated,
"Are not health and welfare laws. These are slavery laws, pure and simple."
Multiple previous court cases like Korematsu versus the United States were referred to in the trial, as well as the 14th Amendment. In Korematsu, it was stated that, quote, "The Equal Protection Clause demands that racial classifications, especially suspect in criminal statutes, be subjected to the most rigid scrutiny, and if they are ever to be upheld, they must be shown to be necessary to the accomplishment of some permissible state objective, independent of the racial discrimination, which it was the object of the 14th Amendment to eliminate." End quote. After a grueling 2 months of defending their points, the Supreme Court made their decision. In a unanimous 9-0 vote, the Supreme Court ruled that all sections created as a result of the Racial Integrity Act of 1924 unconstitutional under the 14th Amendment. Chief Justice Earl Warren wrote in his opinion of the case, quote, "Under our Constitution, the freedom to marry or not marry a person of another race resides with the individual and cannot be infringed by the state." End quote. With this ruling, the group of anti-miscegenation laws were stricken from the Virginia Code, as well as the codes of 16 other states. However, the effects of this case did not stop there. Hirschkopf said while interviewing about how this affected later cases, quote, "But there are certain other rights that when they talk about in the introduction to the Declaration, they took out certain inalienable rights, life, liberty, and the pursuit of happiness, but inalienable rights. Those rights that are not expressed in the Constitution, but they are so fundamental to a democratic society that the Supreme Court has said we will recognize them and we will protect them." End quote. The case stated that the right to pick a partner regardless of race is needed for life, liberty, and the pursuit of happiness. It didn't just break barriers in miscegenation and segregation. The case was cited in Casey versus Planned Parenthood, and most importantly, the decision in Obergefell versus Hodges. Obergefell versus Hodges legalized same-sex marriage. The Loving v. Virginia ruling was used to justify same-sex marriage because SCOTUS ruled that the 14th Amendment gives the right for a person to choose their partner. With this previous ruling, same-sex marriage was finally legalized. The ruling in Loving v. Virginia was used to justify the legality of abortion protocol and same-sex marriage. The effects of Loving v. Virginia 48 years after its ruling still affect the decisions made in today's world, as shown through the multiple rulings in the years after the case. The Loving v. Virginia Supreme Court case was an important case in securing the understanding of our Constitution and the 14th Amendment.